Hi, my name's Gavin, and I'm the Senior Managing Solicitor of Emerson Family Law. Today, I'd like to talk to you about divorce and the essentials of what you need to know about divorce in Australia. So a divorce in Australia is the formal and legal recognition at the end of a marriage. A divorce order will legally sever the marriage on a final basis. Now, there are frequently asked questions about divorce, and we'll go through the top questions that we normally encounter from clients about divorce. The first question: can I apply for a divorce order in Australia? You can apply for a divorce if either you or your spouse regard Australia as your home and intend to live in Australia indefinitely, or you are an Australian citizen by birth, descent, or by grant of Australian citizenship, or you ordinarily live in Australia and have done so for 12 months immediately before filing for divorce. Now, you need to prove that you and your spouse have lived separately and apart for at least 12 months, and there is no reasonable likelihood of resuming married life. Despite popular belief, in Australia, you do not have to prove who was at fault. Regarding separation, you can be separated under one roof. For example, sleeping in separate bedrooms, clear division of household chores, and payment of household bills, etc. Many married couples in Australia, for one reason or another, whether it's for children, finance, or convenience, will remain living in the matrimonial home, even though there has been an irretrievable breakdown of the marriage. As at 9th of December last year, same-sex marriage became legal in Australia. So therefore, same-sex couples whose marriages are recognised can access Australia's family law system, including divorce, regardless of when the marriage was solemnised. The divorces of same-sex couples who divorced overseas before the 9th of December 2017 are also recognised in Australia. Same-sex couples who divorce overseas on or after 9th of December 2017 will have their divorce legally recognised in Australia in the same circumstances as any other married couple. Second question: how do I apply for a divorce in Australia? The divorce process in Australia commences by completing an online interactive application for divorce, which can either be a joint application, whereby you and your former spouse are joint applicants, or a single application, whereby you are the sole applicant and your former spouse is the respondent. There is also a compulsory court filing fee of $865 GST exempt, payable upon the date of filing the application for divorce, unless in some cases, if you hold certain government concession cards or you are experiencing financial hardship, you may be eligible for a reduced fee. Now, to be eligible for a reduced fee for a joint application, both you and your spouse must qualify for the same reduction. If only one spouse qualifies for the reduction, then the full fee applies. The court does not set the fees payable. Court fees are set by federal government regulations. Question 3. What does a court consider in a divorce application? The Australian Family Law Act established the principle of no-fault divorce in Australian law. This means that a court does not consider why the marriage ended. The only ground for a divorce in Australia is that the marriage has broken down irretrievably. That is, there is no reasonable likelihood that you will get back together. You must have been separated for at least 12 months in order to satisfy the court that the marriage has broken down irretrievably. If there are children aged under 18 years, a court can only grant a divorce if it is satisfied that proper arrangements have been made for them. Question 4. Can I oppose a divorce application? If you've been separated for more than 12 months, there are few opportunities to oppose a divorce application. You can only oppose the divorce where there has not been 12 months separation, as alleged in the application, or the court does not have jurisdiction. So if you don't want the divorce granted, you must complete and file a response to divorce and appear in person on the divorce hearing date. You need to set out the grounds on which you seek the dismissal in the response to divorce. If you file a response, you should attend the divorce hearing. If you do not attend, the court may ultimately decide the divorce application in your absence. If it is difficult for you to attend in person, you may ask the court to appear by telephone. Question 5. Do I have to attend the divorce hearing? If there is no child of the marriage aged under 18, you are not required to attend the court hearing. This applies for both sole and joint divorce applications. If you have made a joint application, you and your spouse are not required to attend the court hearing, even if there is a child of the marriage aged under 18. If you have made a sole application and there is a child of the marriage aged under 18, you, i.e. the applicant, are required to attend the court hearing, unless circumstances prevent you from attending. Question 6. We're getting divorced. So will decisions about future arrangements for our children, property, spousal maintenance be made at the same time? The granting of a divorce in Australia does not decide issues about property settlement and or spousal maintenance, or even parenting arrangements for your children. If you want to make arrangements about these particular issues, you can make an agreement with your spouse and file it with the court, or seek orders from a court where you and your spouse cannot reach an agreement. For parenting cases, you also have the option to make a parenting plan. If you want to apply for spousal maintenance for yourself or a division of property, you must file a separate application within 12 months of the date the divorce becomes final. Otherwise, you will need the court's permission to apply. Question 7. I've applied for a divorce in Australia. So, is it safe to set a wedding date for my new marriage? You should not make firm plans to marry on a specific date until the divorce order is finalised. In most cases, the divorce order takes effect 1 month and 1 day after the divorce is granted. So you should not assume the divorce will be granted at the first court hearing. For example, you may be told at the hearing that you need to provide more information. Question 8. I married overseas, so can I get a divorce here in Australia? If you were married overseas, you can apply for a divorce in Australia if either you or your spouse regard Australia as your home. You intend to live indefinitely in Australia, or you are an Australian citizen or resident. Or you are an Australian citizen by birth or descent. You are an Australian citizen by grant of an Australian citizenship, or you ordinarily live in Australia and have done so for 12 months immediately before filing the divorce application. And you must provide the court with a copy of your marriage certificate. If your marriage certificate is not in English, you will need to file an English translation of it and a supporting affidavit from a qualified translator. And the final question, I got divorced overseas. Is that going to be recognised in Australia? Yes, you can apply for a divorce overseas, and Australia will recognise a divorce if it was effected in accordance with the laws of that country. To find out more, please visit our website on www.emfl.com.au or give us a call on 07 3211 4920 to arrange a no obligation fixed fee initial consultation today. Thank you.